Hey, sports fans. Game one of the new Ben Johnson era Chicago Bears is in the books. And last night, they lost to division rival Minnesota Vikings. Minnesota Vikings run by a rookie quarterback and a defense that was pretty stifling. What does that have to do with employment law? Well, the defensive coordinator of the Minnesota Vikings is Brian Flores. In June, Brian Flores was allowed by a federal judge to move forward to trial in his case against the NFL and a number of sports teams, a number of NFL teams. The reason why his claim is discrimination. A couple of years ago, he was up for the position of head coach of the New York Giants, and he got a text from Bill Belichick congratulating him on getting a job for which he had not yet applied for or interviewed for. And it turns out that Bill Belichick had made a mistake and meant to send the text to another Brian Dable, who is now the coach of the Giants. Because Brian Flores, a black man, had never actually interviewed for the job, the NFL had violated essentially its own rule called the Rooney Rule, which requires that during an interview for a head coaching position, essentially a team must interview a diverse number of applicants, which the Giants did not do. And so Brian Flores filed the lawsuit for discrimination. Actually, it was a class suit. There were a couple of other coaches that joined him in this. The interesting thing is that it turns out most coaches, they sign arbitration agreements. Ironically, the arbitrator is the NFL itself. That's never a good start when the judge and jury are the very same person that you're suing. Not a great start. So the federal court determined that was unfair and allowed his suit to move forward to trial in federal court and outside of the NFL's normal arbitration. Seems that he's doing okay because his defense pretty much handled the Bears with not a lot of problem. But it'll be interesting to see how this lawsuit pursues later down the road.